In the latest Parliament sitting held on October 14, Minister for Education Chan Chun Sing addressed pressing questions surrounding the legal case of former Transport Minister S. Iswaran. This follows Iswaran's charges under Section 165 of the Penal Code, which states that a public servant cannot accept anything of value from someone with whom they are engaged in an official capacity, unless proper or adequate payment is made. Alongside these charges, Iswaran also faced an additional charge for obstruction of justice. The charges initially brought against Iswaran were under the Prevention of Corruption Act. However, as the case progressed, these were amended. Minister Chan emphasized during the sitting that the amendment of charges is a common occurrence in legal proceedings. He clarified that as new developments unfold, the prosecution or defense may see fit to adjust the charges accordingly. In response to Member of Parliament Sylvia Lim's questions, Chan pointed out that Section 165 is still a form of corruption charge, which applies specifically to public officers. Unlike other forms of corruption charges, Section 165 does not require proving a quid pro quo, it only requires proving that something was received. Further questions were raised regarding the thoroughness of the investigation conducted by the Corrupt Practices Investigation Bureau, CPIB, and the Attorney General's Chambers, AGC. In response, Minister Chan maintained that both agencies had done a thorough job, and he explained that the amendments to charges were part of regular legal processes, rather than any sign of weakness in the case. Lim also raised concerns about the sentence imposed on Iswaran, which was a 12-month jail term, longer than what both the prosecution and the defense had suggested. Chan highlighted the distinction between what the prosecution asks for and what the judge ultimately decides. He reminded the members that judicial discretion plays a key role in sentencing, and it is not unusual for a judge to impose a sentence beyond the recommendation. Turning to the broader issue of public trust, Chan spoke about the high expectations placed on public servants. Whether directly employed by the government or serving in roles on behalf of the government, individuals are expected to uphold standards that preserve the integrity of Singapore's public service. He stressed that gifts or benefits from anyone associated with a public servant's official duties are simply not acceptable in Singapore, and any leniency on this matter would undermine the trust and confidence the public places in the government. MP Julkarnain Abdul Rahim raised the concern of whether these stringent rules might discourage private sector talent from taking on public service roles. Chan dismissed these concerns, asserting that a system ensuring clean and honest governance is more likely to attract the right people. He further assured that as long as individuals serving on statutory boards act with professionalism and integrity, they have nothing to fear. When asked about the potential need for reviewing Singapore's anti-corruption laws in light of recent developments, Chan cautioned against knee-jerk reactions. Instead, he advocated for identifying whether issues stem from individual misconduct or systemic failures. He noted that if the rules are clear and were simply ignored, the focus should be on taking decisive action against the offender. However, if the rules are unclear or inadequate, then they should be updated to reflect current realities. The case of S. Iswaran has certainly raised important questions regarding the expectations placed on public servants, the integrity of investigations, and the evolving nature of legal charges. What are your thoughts? Do you think the amendment of charges reflects a fair judicial process, or does it raise concerns about the initial investigation? Leave your thoughts in the comments below. And don't forget to like, share, and subscribe to 2230 for more in-depth coverage of current events.